All right, this system drives me crazy. It's shut off and I never know when it shuts off. So where was I? Okay, original jurisdiction. Off you go, guys. Shoot, shoot, shoot. Off you go. Out, out. Original jurisdiction is when you file a lawsuit directly with a court, with the Supreme Court. The Supreme Court has both original jurisdiction, where it takes cases without having first gone to a lower court, and appellate jurisdiction, where it reviews lower court decisions. All right? What kind of cases? Suit between states. So Arizona and Colorado sue each other over the Colorado River. It will go straight to the United States Supreme Court. I guess if you sue an ambassador to a foreign country, you sue the ambassador from France, it goes straight to the Supreme Court. There are very, very few of these cases, all right? The reason why we talk about this is because of Marbury versus Madison. In Marbury versus Madison, Marbury passed up lower federal courts and filed his lawsuit for a writ of mandamus straight with the Supreme Court. That was the whole problem with the decision. Remember, Marshall, Chief Justice Marshall in Marbury versus Madison said, hey Marbury, we should order Madison to give you your judge's commission because you were properly nominated and confirmed, but we can't because the Supreme Court, because the Constitution defines our original jurisdiction as this and only this, and your lawsuit against Madison for a writ of mandamus is not on this list. Therefore, the law that Congress passed that added writs of mandamus to this list violates Article 3 and is therefore unconstitutional. I know, crazy, crazy. Don't get, public ministers is a term involving foreign officials, not people like the Secretary of State. A minister is different than a secretary. Minister is somebody from a foreign country. Okay, appellate jurisdiction. Appellate jurisdiction. Sam, out. Okay, so what kind of cases does the Supreme Court hear when they are reviewing lower court cases? Well, they are cases with a federal question that will either come from a lower federal court, a district court, and then a circuit court. Of course, they could never have taken them at all unless there was a federal question. So they have jurisdiction to review all cases coming from the lower federal courts, because all of those have a issue of federal law. But interestingly, they can also review state lower courts if there is a federal question. This is what happened in Gideon versus Wainwright, right? He was convicted in state court, but he raised, he raised a federal defense, all right? So there was a federal question in his case. So after the Florida Supreme Court ruled against him on the federal question, he could appeal just the federal question only to the Supreme Court. All right. Now, the Supreme Court can also hear lower federal court appeals on diversity cases, which is weird because those were decided on state law, but because those cases are just going to go to the Supreme Court, U.S. Supreme Court. They're not going to go to the state Supreme Court. Okay, so how does the Supreme Court hear cases on appeal? They do it by granting cert, by granting a writ of certiorari petition. All you have to know is grant cert. So what is that about? Okay, I'm going to skip that one slide. We'll go back to it. Okay, look. In 1925, Congress passed the Certiorari Act, which said, hey, Supreme Court, you don't take all the cases. You don't have to take cases on appeal. You can decide what cases to take. and you can take them by granting a writ of cert, all right? If you are a party and you are unhappy about a result on a federal question, either from a federal court, a federal district court, and the federal circuit court, you can say, hey, I don't like the ruling, or even in a state court. Now, you have to go all the way through the state system like Gideon versus Wainwright did, and then say, I don't like the ruling. Then you can file a petition for writ of cert to the Supreme Court. This is what happened in Gideon versus Wainwright. He went all the way through the state system saying, I was denied my right to counsel, and the Supreme Court granted cert. Now, they don't do this. They do this with a very small percentage of cases, about 80 out of 8,000. This is why it was so amazing in Gideon versus Wainwright. Remember that clerk opening up his paper petition and getting the attention of the Chief Justice? That was a miracle. That was a rarity, because only 80 out of 8,000 cases did the Supreme Court grant cert on. All right, it's called granting cert. By the way, in this current term, the Supreme Court has accepted 73 cases that it is going to rule on. So, by the way, how does the Supreme Court grant cert? You remember this from Gideon versus Wainwright. It is the rule of 4. If 4 justices agree to hear the case, the Supreme Court will take the case. What kind of cases? Well, and this is important. You have to know this, all right? What kind of cases? Out of 8,000, what 2 factors are very important to the Supreme Court? Well, the first one is when there is an important principle of federal law. Well, in Gideon versus Wainwright, it was, hey, what is the scope of your right to counsel if you are a poor person? That was perceived to be an important issue of federal law. The other typical circumstance is when there is a conflict among the circuits. This actually happened, which is why the Supreme Court took the gay marriage case, Obergefell, in 2015, I believe it was. The Ninth Circuit said state laws restricting marriage to be between a man and a woman violated the Equal Protection Clause of the 14th Amendment. And the Due Process Clause, because marriage was a fundamental right. And the Equal Protection Clause, because it created classifications that were being treated differently. I know, are gays a suspect class? The dissent screamed about that, saying, hey, wait a minute, gays aren't a suspect class. But the very same case came up in front of the Sixth Circuit. What's the Sixth Circuit? The Sixth Circuit is... Where is the Sixth Circuit? The Sixth Circuit is, Florida, Georgia, Alabama, Tennessee, Kentucky, and Ohio, and Michigan. And the Sixth Circuit said laws that define marriage between a man and a woman are not unconstitutional. Therefore, until the Supreme Court stepped in and ruled, you could get married in any state in the Ninth Circuit as a gay person, but you could not get married in any state in the Sixth Circuit. Weird, right? That is called a conflict between the circuits. And when there is a... Quiet! Sam and Lily! Quiet! Get in here! Come on! Come! Sorry, they're out there barking. Come! Here, I'm going to, hold on a second, I'm going to put them in here really. Come on! Come on, come on, come on, come on! Come on, in! Let's go, get in! No, get in, come on! Come on, come on! Now! Come on! Come on, you're okay, good job. No wrestling, shush! Shush! Oh, you crazy kids. They get all fired up. All right, you guys still with me? Okay, all right. Okay, so You have to know this. Important issue of federal law or a conflict among the circuits. Those are the kind of cases the Supreme Court is likely going to take, all right? By the way, if the Supreme Court does not grant cert, then the lower decision stands, whether it is a U.S. Circuit Court decision or a decision by the highest court in the highest state court. If the Supreme Court is tied, sometimes they're tied. Sometimes a justice will recuse themselves because they would be perceived to have a conflict of interest. For example, several justices, including Rehnquist, were appointed after working in the Department of Justice on cases that later came in front of the Supreme Court. If they had worked on that case as a government lawyer, then they recuse themselves so it doesn't show that they are biased, all right? So you can have a 4-4. If there's a 4-4, the lower decision stands. Okay, so the moral of the story is you get to the Supreme Court to have them review your case on appeal by petitioning for a writ of cert. If they grant cert by the rule of 4, they will take their case. They hardly take any cases. What are the two factors? An important issue of federal law or a conflict between the circuits. All right. Tomorrow, I'm going to do another video on our AP issues. All right. So we'll see you tomorrow.